Welcome to the Far and Beyond podcast, hosted by the Contracts and Fiscal Law Department at the Judge Advocate General's Legal Center and School. This podcast is for the federal government attorney navigating the complex intersection of acquisitions and fiscal law and policy. I am your host, Major Ellie Sewell.
And I'm Major Ed Callahan.
Together, we are your co-hosts. On this episode of Far and Beyond, we have a special guest with us today from the Government Accountability Office. Welcome.
Thank you. I'm Kristine Hassigner. I am an assistant general counsel at the Government Accountability Office, and I work in the Appropriations Law Group, and I do fiscal law.
Ms. Hassigner was just able to give a presentation to our new developments course, and we greatly appreciate it, and we really wanted to follow up with some of these topics because I feel like these are what's on everybody's minds. It's new things, as you were saying before, that you're seeing a lot more this year than you had in the past. One of the things that we've talked about in the podcast before, but more from a historical perspective or an introductory perspective, is the Impoundment Control Act. I know because you just said it about an hour ago that this is something that's been coming across your desk in your office pretty frequently. Would you be able to walk us through maybe a couple of the cases that you saw, maybe highlighting some of the rules that our listeners are going to be able to look to in the future?
Yes, absolutely. The Impoundment Control Act was really dominant in GAO's fiscal law portfolio this past year. We issued several decisions, both finding improper impoundments occurred, but also finding that no impoundment occurred. And it's really a broad spectrum of factors that we look at when we decide whether there's an impoundment or not. It's definitely not a black and white question. It's very facts and circumstances. And so we like to talk about our decisions to really illustrate what those factors are so that agencies can use it as guidance as they are implementing their programs.
That's excellent. So, ma'am, I'm wondering if we could maybe take a step back and talk about the way that's supposed to work prior to a GAO review of, maybe defining lines. How does the Impoundment Control Act actually outline the proper procedures for impounding, not spending money that you're allocated?
Yeah, the Impoundment Control Act sets out a very particular process under which an administration can permissibly withhold funds, but only in two circumstances. And the Act lays out what those circumstances are, as well as the steps that have to happen when an administration wants to do that. So the first circumstance under the Act is called a proposed rescission. And this is when an administration does not want to spend the money that Congress has provided it for any purpose or any reason. It just would like Congress to take that money back and have it go away. And if that's the case, then the president submits a proposed rescission to Congress and explains, where we'd like you to rescind this amount. This is the reason, the program affected, those types of things. And Congress can consider that for a period of 45 days. And during that 45 days, the president can actually withhold those funds. So he can sit on those funds and not spend them while waiting for Congress to either enact the rescission, which means the money does actually go away, or do absolutely nothing, in which case the administration is required to spend that money. After that 45 days, if we don't have a law, they have to spend it.
Okay, and we actually saw a couple of those this year, didn't we?
Yes, we had two of those this year. We had one special message come, which was a proposed rescission. They're reported in a special message. One was submitted in early June, and it proposed rescissions from 22 appropriations, and GAO reviewed that special message and determined that it met the requirements of the Impoundment Control Act, all the required reporting elements. And Congress ultimately, at the end of July, enacted those rescissions. So that money did, in fact, get rescinded and go away. The other special message was submitted in August, late August of 2025, and that proposed rescissions from 15 foreign aid accounts. And GAO also similarly determined that while it met all the elements required under the Impoundment Control Act for the special message, we did make a note that the amounts proposed for rescission would be expiring on September 30th. And so, our case law says that the administration must still spend those funds before they expire and may not withhold them through September 30th while waiting for the 45 days to elapse.
So it was effectively giving Congress less time to make the decision as to whether or not they would enact a rescission.
Yes. In this case, if they wanted to enact it, they would have to do it before the funds expired. Otherwise, our position, GAO's position, is that the administration is required to spend those funds before they expire.
And I understand, though, the Supreme Court also sort of weighed in on this issue.
Yes, this is a case called Global Health Council, and it's been making its way through the courts since about February, and it has to do with a number of actions that the State Department and USAID have taken to implement various executive orders that are ordering cancellation of grants and contracts and reorganizations of those agencies. And so that case ultimately made its way to the Supreme Court in September after this special message was submitted. And the impact, really, of the Supreme Court's order in September was that a portion of that special message money was allowed to expire without being spent.
Okay, so that's one of the ways in which the Impoundment Control Act can be used properly. Are there any other ways?
There's another mechanism under the Impoundment Control Act that allows the administration to delay funds, and this is called a deferral. So if an administration just wants to temporarily not spend the funds, and they can only do this for contingencies or as otherwise provided by law or to achieve savings, that's what the law says. If they want to delay funds for one of those reasons specified in the law, they can do that. And again, they have to submit a special message explaining to Congress what's going on. And again, they do have to ensure that those funds are ultimately prudently obligated before they expire.
And correct me if I'm wrong, but it really is only for a few circumstances they can do that, for like efficiency, savings, contingencies.
Yes, that's exactly right. The Impoundment Control Act lays out only 3 circumstances or scenarios in which a deferral can occur. And as you mentioned, it's for contingencies as specifically provided by law or to achieve savings.
Did we see any deferral special messages for deferrals this year?
We did not.
Okay.
No. Both of the special messages in 2025 were proposing rescissions.
Historically, have we seen deferrals?
There have been some, but not in recent years. In the past several administrations, it's really been proposing rescissions.
So we're talking about the ones coming up this year because, they're what's been coming across your desk, and this is a new developments update. But are these special messages common? Do we see them from all administrations? Is it more common to see them each fiscal year than to not see them?
There have definitely been administrations that have not submitted any special messages. And then there have been administrations that have submitted one or more special messages. So it's hard to categorize, how common they are. It's really up to the particular administration to decide whether they want to use the authorities and the mechanisms in the Impoundment Control Act and take advantage of those abilities to withhold that the Impoundment Control Act provides or not.
So we've been talking about how the Impoundment Control Act really is talking about mandating spending. It's really requiring the president to spend the money that Congress has apportioned. Does it require every penny to be spent?
No, GAO's position is that it is prudent and a sound funds control practice to actually intentionally and strategically and consistent with their historical practices reserve some small amount of funds that the agency thinks is appropriate to potentially make contract modifications later or do other types of actions that would require that expired money still be available to be used. And so we don't read the Impoundment Control Act so literally to mean that you have to have your account at zero in order to avoid a violation. We would look at the agency's historical spending practices, and if they're keeping a reserve that's sort of commensurate with historical practices and for good funds control reasons, we would have no issue with that.
No, that makes sense. As someone who has reviewed many contract modifications and done a PTA analysis, purpose, time, and amount, yes.
Yeah, I'd be more nervous if we were on September 30th and looking at a $0 bank account.
Oh, I'd
be if we had something left.
Very nervous.
So then if we could turn a little bit to some of the cases you saw this year, and I won't make you go through every one of them because I know that's what you literally spent your last year doing. Let's start with one that maybe highlights a easier way to say this was not a violation of the Impoundment Control Act.
Sure. A really good illustration of no violation of the Impoundment Control Act is a decision we issued about the Department of Homeland Security. there was an executive order that required reductions in force throughout the government. And so DHS, the agency here, implemented that executive order by eliminating staff in full in 3 different of its offices. And we looked at that from the Impoundment Control Act perspective, and we looked at some obligation data and the appropriation account at issue there and determined there was not an impoundment. And the key driver there was that the appropriation at issue here was a large lump sum amount that could be used for a wide variety of purposes. And so even though DHS was no longer funding those 3 offices, it was still spending at a robust and normal pace that appropriation for other permissible purposes. And so in order to have an impoundment in any case, you have to see a delay or withholding. And in this case, the obligation data was showing that funds were flowing and that they were not withholding any amounts in connection with the reduction in force.
And that makes sense, having, the agency has that discretion to use that large lump sum. So whether they want to spend it on personnel or some other program, yes, that makes sense that it would not be considered, they're not withholding the money, they're spending it.
Yeah, big concern being that they spend the money, not necessarily what they spend the money on. I suppose that would be a different GAO opinion on a purpose question.
Yes.
Now, did you see any cases that were more clearly defining a violation of the Impoundment Control Act?
Yes, one particular case comes to mind, and it has to do with the Institute of Museum and Library Services. This case has to do with a executive order that was issued in March that required the reduction of functions at the Institute to wind down to only preserve those functions that were required by statute. So only functions that are mandated by statute and the personnel that carry out those functions could remain. And the executive order contemplated that everything else would basically be reduced and eliminated. And so we took a look at this from the impoundment perspective, and there was litigation that had to do with this exact same matter. And some of the filings in the litigation were quite telling for us in terms of our analysis, because there were officials from the Institute, the head of the Institute, declaring in these litigation files that, not only were they terminating grants and reducing functions, but they also had no intention of using that money for anything else. They just were going to let it expire without being used at the end of the fiscal year.
Well, that had to be helpful for your analysis coming off of that.
So that was great evidence, because when you read what the proposed rescission is supposed to be, it is that exact scenario. They, an administration just doesn't want certain things to be funded, then they can propose that money for rescission. And in this case, we would have expected the administration to propose that that money from the Institute be rescinded through the Impoundment Control Act process, not on its own.
That makes sense. My guess, though, is that while those are 2 good extremes used to highlight it, most of your cases are kind of falling into a kind of middle, more gray zone area. And I know you saw a lot of them, but do any of them come to mind? My guess is this is so fact-specific and circumstance-driven, but any of them come to mind that maybe you can highlight what analysis GAO is putting into it, and therefore we should be putting into it in the field?
Yes, there are always a number of factors that we would look at in any impoundment analysis. And one case where we really had to look at several different factors in order to reach our conclusion had to do with the Department of Interior. There was a law passed in 2021 called the Infrastructure and Jobs Act, the IIJA, and this law authorized and provided funds for a number of projects. It created a grant program at the Department of Interior for it to award grants to construct water recycling systems. And subsequently, on January 20th of this fiscal year, an executive order was issued that required agencies to pause disbursements of these IIJA funds and review all their programs for consistency with the executive order and with laws. And so Interior followed the orders of the executive order, paused their grant program here, and undertook a review. So we looked at this from the impoundment perspective and said, is that 30-day pause that Interior instituted here, they paused their disbursements, they paused the program, they're doing this review, does that constitute an impoundment? And this one wasn't necessarily clear cut. We had to look at lots of different factors. So some of the factors we considered were the amount of discretion that Interior has to implement this particular grant program. Was it the type of statute that was so specific and directive that it wouldn't even be reasonable for Interior to reconsider or decide if it wanted to pivot or take a different approach? And the answer there was no. Interior had quite a bit of discretion to decide how to implement the program, and so that made the pause more reasonable. We also considered that the pause was only for 30 days, and this was a multi-year, multi-million-dollar grant program. So a pause of 30 days in the grand scheme of what we were talking about here couldn't really be seen as reasonable, as really effectively causing a real delay.
That makes sense.
In this case. And the Interior Department also expressed a clear intent that they were going to continue obligating after the 30 days. So those are the factors.
Because I know the IIJ was under some scrutiny this year for a few various cases. So, and I know in one of the other decisions you had, there was a clear line item specific appropriation in there. I think that was for the Renew America's Schools program. So this one was not a line item specific purpose. This was more of a agency, here's the money, here's sort of what you should spend it on. And they had a lot of discretion on how to do it.
Yes, that's right. The appropriation here and just the overall statutory authority that Interior had over the large-scale water projects program was greater than what the Department of Energy had in our other case that had to do with the Renew America Schools program, where it was a much more constricted authority play there.
All right, Ms. Hassigner, we really appreciate you coming and talking to us today. Appreciate all of the kind of guidance and education that GAO provides both to the schoolhouse here through the electives, through things like this, and out in the field. I'll tell you, when I got into Fiscal, GAO Red Book was one of those bookmark tabs that I had at the top and just had to live out of all the time. Shameless plug for our listeners, though. Also, our desk book is pretty good here at the Fiscal Law Department, so take a look at that one.
Mm-hmm. Thanks for having me.
No, this was great. Thank you so much. Thank you for joining us today on this episode of Far and Beyond. Please make sure to follow us and subscribe on your favorite podcast platform.
And we will be putting all of the links and the GAO helpful resources in our show notes. Please reach out if you have any questions or comments. We'd love to hear from you. And look forward to talking to you again next time.
The views expressed today are those of the presenters and not that of the Judge Advocate General Corps, the Department of the Army, the Department of the Air Force, the Government Accountability Office, or the Department of War.